WDXE and live on Facebook and YouTube with Stan Pierchoski. Stan Pierchoski, is those headphones not working?
Half of them are.
Half of them aren't? Well, that happens. That happens. Stan Pierchoski and the Friday hour for him and estate planning. And
Bulletproof estate planning.
Bulletproof estate planning. Thank you for being here again.
Oh, no problem.
And the microphone is yours. I'm going to make sure that we're on like we're supposed to be.
Okay, sounds good. Yeah. No, this is the great experiment by WLX radio station going to their WDXE going to talk radio. So, I'm excited and happy to be a part of it. So we do this hour every week. If you've been listening to me, you know. If you haven't, we do it every week from 8 o'clock to 9 o'clock on Friday morning. We call it Bulletproof Estate Planning, and it's an interactive show. We'd like people to call in. If you have a question about whatever I'm talking about or estate planning in general, or, you can call in and ask. And we encourage those phone calls because it's that kind of a show. So that telephone number is 931-766-9393. So if you want to call in and ask a question, I'll be more than happy to field that question and give you an answer. So I'm going to pick up kind of where we left off last week. I'll do a quick recap of what we did in the last couple of weeks because as I talk about estate planning, it's kind of a progressive topic. We kind of start with the beginning and kind of move through the whole process and the options and stuff like that. So, but before I do, I want to talk about what's coming up. I have one of my seminars. I do this about every 6 weeks there's not really any set schedule, but we do them several times throughout the year. And the next one we have come up actually is tomorrow. And it's right here at WLX in the back. This building used to be a bowling alley years ago, so you got this big building, and in the back they have the Country Cafe where people dance on Friday nights, and nice big venue. And so, the station is gracious enough to allow us to use that, and, I thank them for that. And that's where we're going to have it. So it's tomorrow at 10 o'clock in the morning. We have whenever we do Saturday seminars, we have them at 10 o'clock, and we call it Wills, Trust, and the Nursing Home. And I kind of recap and go over a little more of a whirlwind in the short period of time I have, the kind of stuff that we talk about here on the radio. The advantage we have on this hour radio show is we can do a little more of a deep dive into particular subject matters. Some people like a little more information, some people not so much, but it's there if you want it. So tomorrow, 10 o'clock, June the 10th, tomorrow Saturday here at WLX in the back of the building, the WLX Country Cafe. I often tell people if you look for the big tower, it's the biggest tower in Lawrenceburg, and right where that tower hits the ground, there's a set of double doors, and that's the right place. Come on in, you're there.
Correct.
Now it's going to be tomorrow, so we like to have RSVPs. And the only reason is because it's not like a formal registration. Everything's informal. We just like a head count because we like to get tables and chairs set up, and there's always walk-ins, and they're welcome. And I just don't like scrambling at the last minute putting up tables and chairs. But, if you want to walk in and you don't know if you can commit until the time comes, that's fine. Come on. There's always people that can't make it at the last minute and some folks that can. So you are welcome. Had somebody call yesterday and say, is it too late to register? And it's not that kind of registration. We just like to, we usually have some very light refreshments. And we like to have enough.
Sure.
Miss Tammy makes those, and, it ruins her day if there's not enough. So you know how they are. And so that's the only reason we like the RSVPs. It's very informal. But the presentation itself, it's sort of informal, but it is a lot of information. So if you come to this, don't, I get people call all the time and say, well, what's the catch? Are they going to try and sell me something, or do I have to sign something? The answer to that is no. This is a free educational seminar, and I focus on the word educational. And that's what you're going to get. At 10 o'clock, we're going to start pretty promptly. And it's going to be nonstop for an hour to an hour and 10 minutes or so. Just depends on how off track I get. Sometimes it drags out, but I try not to be. But it's just, the girls in my office call my seminars a fire hose of information. And they sort of need to be, in my opinion. But we're going to answer a lot of questions that you have. If you're giving this any thought at all, any kind of estate planning or some of the stuff I've been talking about, what's going to happen to my stuff if something happens to me? What if I go to the nursing home? What if a loved one goes to the nursing home or something? What if I have minor children? What's going to happen to them? If any of these things are of concern to you, you will benefit by coming to this seminar. It is like I said, it is a fire hose of information, and it's not a sales pitch. There's no free meal. We hit the ground running, and it's just all, nonstop fact, nonstop information. So be prepared for that. And, just like on this show here, I encourage questions. As a matter of fact, I love questions. At the end of the presentation, I open up the floor to question and answers, and that's my favorite part of the whole thing because it tells me what's on their mind, what they're thinking of, the real life situations, and that's my favorite part. So on this show, we encourage questions. Call in. Don't be shy. Just call in and ask. You don't even have to give your name. Just call in, or the facts. If it's personal facts, we'll make them generic. And ask. And if you come to this seminar, if you have questions already, bring them with you. If you develop questions during the presentation, write them down. And at the end, the only thing I ask is we wait till the end for the questions. And then I will stay as long as I need to. I've been here till 1 o'clock in the afternoon after these sessions answering questions. I don't want anybody to leave with a question on your mind that's not been answered. So by all means, don't worry about it. Take advantage of this time that I offer, and that's exactly what it is. So let's get informed, because I always take the position that if you don't know what your options are, it's not possible. It's just not possible to make an informed decision, and that's what we want, an informed decision. So the best scenarios, know the options, know what they do, know what they don't do. Like we talk about this show, we talk about a will, what it does and what it doesn't do. If you want a will, that's great, but you ought to know what comes with it. There's some baggage that comes with a will that we talked about last week, is this whole probate process that your heirs will go through. So, if you don't want that, then maybe that's not the best solution. But you need to know that ahead of time, because I have had so many people come in and say, I have a will, but I sure don't want my kids to have to go through probate, and they're surprised to hear that is a legal assurity that that's going to happen. So we talk about all that. So again, give my office a call at 931-363-7222 and tell either Miss Tammy, Miss Alex, or Miss Courtney that you want to come to the seminar, or even just say, I'm thinking about coming, don't know if I can come, but if I want to show up. If we think you're coming, we'll have enough tables and chairs for it anyway. So
I would advise that to anybody that's got some free time in the morning, if you haven't done this, to take advantage of what you're doing here.
And typically, these seminars have evolved a little bit over the years. Typically, we would do them on Thursdays, and we do them about at like 1 o'clock in the afternoon, 1 or 2 in the afternoon. Now, we had the idea maybe early last year. It was kind of like by popular demand. We get calls from people that say, listen, I want to come to your seminar, but I get home on Thursday night and the kids need fed, and I've been at work all day. I can't come to one at 1 o'clock in the afternoon. We get that. Life gets in the way, and so we had them at sometimes we would have them at 6 in the evening, and we got to feed the family and stuff. So we sort of got a bunch of requests. Can you ever do them on a weekend? Yeah. And so I'd say probably last year was the first time we started doing Saturday ones, and so we did, and we did a handful of those throughout all last year, and it turned out they were very well attended. It fits people's schedule somewhat better, and so we've done more of them this year, and that's why. And it we didn't know, when we first thought about it, I thought, Saturday, everybody look forward to the weekend. You don't really want to do something like this on a Saturday, but I get it. So I want to make the information available. So we still do the ones like at 1 or 2 in the afternoon occasionally. A lot of times over in Pulaski or up in Columbia. We did that one not too long ago in Columbia. Then we have something at the end of July, I think, at the theater in Pulaski that's during the regular. I think I can't remember. The girls keep the schedule, but once we get closer to that, I'll talk about that one. But so if you got an opportunity to spend an hour, it's air conditioning and all, so it's a good environment. Come here, we have to say. It's not a high pressure sales. It's not like we lock the door and say, and you have to sign the line on something. No, not at all. If you don't think what we talk about is a fit for your family, then it's just not a fit. We have some more refreshments, and we'll tell some more stories, and we'll still be friends. It's not that kind of thing.
Absolutely.
Had a gentleman call one time and signed up, and a week or two later, he had his assistant call that he worked for, and she wanted to know. She said, "My boss wants me to call," and I think the Alex took the call and said, "Well, we already have you down for the seminar." I said, "Yeah, but he wanted to know what's the catch." And she goes, "I don't understand. I don't get the question." She goes, "Well, what's going to happen here?" And she says, "Well, Mr. Stan talks about that." She goes, "No, my boss said that no attorney is going to give up 2 hours of his time for nothing." And I chuckle at that, but I get it. I can see where, the industry has not the best reputation. You get, maybe somebody calls their attorney and they get a bill for,
Yeah.
for 0.2 hours.
Yeah.
Or you email them and you get a 0.1. Okay. I don't do that. This truly is a free educational seminar. My goal is to get the message out about these options. I think when you hear what you can do, it will make your decisions with estate planning a lot easier, much easier, and much more fruitful to you, because something we talk about, you're going to say, that's the solution for me. That's what I've been thinking about, and that's what I want. I guarantee it. But if not, that's cool too. I mean, I'm not here to talk anybody into anything or out of anything. I want you to be part of the decision-making process, and you can only do that if you know and understand. Now,
Yes, you need to be well informed.
and I don't make it like a law school lecture. We don't get into it that deep. If you want to know more about like that, I can spend some time on that. But, basic from a superficial standpoint, we need to know and understand how it works. And that's why I like doing these kind of shows. I can get into it a little better.
Sure.
Because when people call me and ask me questions, they are very specific. And sometimes the answer, is a 10-minute discussion to get there, because it's like, okay, here's the question, but let me back up and talk about how that question kind of got there, and then it makes a little more sense when we discuss it that way. So,
Well,
anyway.
I have a bit of a question for you.
Okay, let's go ahead and take that before we get into before we pick up where we left off.
For as long as I can remember being adult enough to know anything about this, there's always been this preaching that everybody needs a will. Everybody needs a will, and there's a mindset in the general public that you should have a will. You should have a will. Well, I guess that's true, but also you've what I'm from listening to you, a will may not be the best. The trust could be a better option. So I'm like, this transition in thinking has happened with me recently. So I thought maybe you might want to address that just a little bit.
Sure. And that's one of the things we talk about at the seminar, and we talk about on this show. Really, I guess we could distill the question. You say the mindset is you should have a will. I think the mindset is more that I should have something that distributes my property to the people I want, or takes care of my family if something happens to me. Now, a will, is the instrument that most people are familiar with. Okay.
Yes.
I get calls all the time say, I thought one of a couple things. One, people say, I've heard of a trust, but I don't know what it does.
Yes.
Or I thought trusts were just for wealthy people. Those are typically what we hear. Now,
Right.
And when you hear me talk about wills, I mean, I'm not a big fan of will. I'll be honest with you. I'm prejudiced. One of the things that got me in this business was what you can do with a trust. But I mean, we do will plans for people if that's what they want. And but I they're so limited, and I already talked about that last week. And so it depends, But if I could make a similarity between a will plan and a trust plan, which they are very different, but in its simplest form, both of them distribute property after death. Okay?
Yes.
We talked about that. Now, so if you think you need a will because those things I talked about, who's going to take care of my family, where's my stuff going to go, that sort of thing. If you're concerned about that, you can accomplish it with other options than the will. You just may not have heard of the other options. And that's what a trust is. It's another option. I think it's a better option, and that's where we're going to start with today.
Good deal.
But the advantages of the trust, but both of them do the same thing. So if you say, have a mindset, we need to get a will, really let's expand that mindset and say we need to do estate planning. And when we do the planning, the best way to approach is let's sit down and figure out what are your goals. Okay, so let's take Mr. Jeff Hood and say, sometimes I'll tell people the best way for me to help guide you through what's the best solution is if you would fast forward to the end and explain to me the ideal end result. You know what I mean?
Yes.
So, nobody likes to think about their mortality, and that's exactly what we're telling you to think about. But, you just need to get past that and to say, okay, if the ideal end result is, hey, I've got these minor children, and I would like my sister and her husband, who are good, Christian folks, I would like them to take care of my younger children, my minor children, if my wife and I weren't available. And if we weren't available, I want my stuff to go to my wife, or I want it to go to my children to take care of them, or so these are the ideal goals that you tell me about. And if you tell me an ideal goal is, hey, I've got a adult child that's got a drug or alcohol problem, and so my ideal goal is to help him some way or help that person some way or make sure that, I don't leave him property or money that supports that habit and stuff like that. Every family's got these issues, and your ideal goal is different than the next person. And that's what I love about this business. It is unique in every way, shape, and form, and it's fun and it's challenging. I enjoy solving these problems, and many of them can be resolved with the instruments other than the will. The will is very limited, and we talked about the probate process and what can be done, and it has to have sort of an ending and a beginning and an ending. And because of that, we're limited in what we can do. But it is a step. Now, so the choices are really, I mentioned, and I think I already mentioned last week or the week before that there's only 3 possibilities your estate can be in planet Earth.
Okay.
One is you have a will plan. 2, you don't do anything at all, and you have no will. Or 3, you have a trust plan. Those are the only possibilities. And I said that those 3 things only have 2 possible outcomes, because having a will and having no will have the same outcome. They both go through probate. Because we talked about if you have a will, the very definition of the word probate is the proving and establishing of a will.
Correct.
But if you don't have a will, you still go through probate. And I think I mentioned it. You might ask the question, well, gee, Stan, how come somebody who goes to an attorney and goes to the time, energy, effort, and cost of writing out a will and thinking about where my stuff goes and listing it out and drawing it up, drafting it, formally executing it, somebody who does that goes through probate, and somebody who does absolutely nothing at all just says, you know what, I keep putting it off, I put it off, I procrastinate, and it just never gets done. How come they go through the same process? And I said the answer to that is if you don't have a will, the state of Tennessee writes one for you. And it's called the laws of intestate succession. They've already decided your heirs and their percentages. So the difference is you sort of have a will, and that's why you go through probate. The big difference between the two is if you have a will, you have a say in where your stuff's going to go. Okay, you have the probate court will honor what the terms and conditions of the will, but it has to go somewhere, and the decision has to be made. And I remember I said all the decisions I talked about are going to be made. The question is, are they going to be made by you now, when you know what you want, or afterward by the court when they don't know what your morals are or your values, but they have to make the decision. So it's always better. And there again, we come back to that mindset. People think I need a will. I need to make these decisions now. And I agree with it. I agree with it 100%. I think it's much better to do it now. And that way, if you do it now, especially if you do the trust that I'm going to talk about, I can literally almost, we're not allowed to guarantee results. That's one of the things they teach in law school, because you're in court, you can never guarantee a result. But I can get as close to a guarantee as I can get with the trust plan that your stuff will be administered the way you want it.
Yes. Because
of the law, our trust code, and the laws that work in our favor. So it's a much stronger instrument, it's a more enforceable instrument. Mm-hmm. It's not as subject to challenge as the other options, and it's just a stronger way to do it. So does that help with the question you had?
Yes, absolutely.
And the statistics, I gave some statistics one time, and I said the people that die what we call testate, which means with a will, is like 12%, maybe 15. I've seen some statistics on both. But people that die intestate without a will. Now that's not bringing in. I haven't seen statistics on trust. This is just strictly last will and testament. So 85 or 88% of us pass away without a will. So, even though a lot of people think they should do something, procrastination gets in the way, and a lot of times people don't. So that's why we're here to help with that. That procrastination can only hurt us, really. We want to go ahead and bite the bullet, and I think we've been successful in that. By talking about this on the radio and talking about it at these seminars, it gets people thinking about it. The more you think about it, the more it bubbles to the top of the list as, hey, things need to be done.
Needs to be done.
And other things come in there. One is if you're successful in life and you have a lot of wealth, that makes you think about it more. 2, as you age, you think about it more. That's just the natural progression of stuff. 3, if you've ever been exposed to the probate process, directly or indirectly, that's going to make you think about it more.
Sure.
Or if you have some life-changing circumstances, near-death experience, that sort of thing. Those are the kind of things that get us to that goal.
Kind of wake you up a little bit, yeah.
A lot of those are not the preferred way to get woke up, but they have that effect. But so we talk about it. I know we're talking about our mortality, and that's not always fun. And I always like Anthony Hopkins, the actor. made a comment one time, and it was along these lines, and he said, "None of us are getting out of this alive." So when we talk about something happening to us, a lot of folks will say, "Well, when something happens to me, well, that's not a win." I mean, that's a win, not an if. They'll say, well, if I die, that's not an if, that's a win,
yes.
Right? When we talk about long-term care, which we're going to get to here in a couple of weeks, but when we talk about going in the nursing home or long-term care, that is an if. I mean, we don't know if we're going to end up there. Some people do, some people don't.
That's correct.
So that's an if, but it's an if we want to be aware of and cognizant of, and maybe want to mitigate the consequences of that. But so, are we going to pass away? Unfortunately, people say, What do I do if something happens to you, Stan? It's like, well, I plan on living forever, but that, I'm. I know
you may plan it, but it's not going to happen.
That's right. If you're a staunch studier of scriptures in the Word, you're guaranteed 72 years. If you behave, if you follow the Word, and you're a good staunch Christian, you get 72 years. Anything after that is gravy. That's the reward. So, yes, there's going to be an end for all of us, but that's exactly what we're dealing with. And usually around Christmas time, I do a show. I call it the biblical perspectives of estate planning, where we talk about all the times in scriptures that talk about an inheritance. It's really pretty interesting. We'll bring that up again when we get back to the holidays, but. Anyway, so yeah, I think you're right. I think people would have the mindset that they need a will or some instrument to deal with their estate is necessary. And when you talk about estate planning, it's not all after death. Some of the things we do, any good will plan or any good trust plan, deals with the things that don't survive death, which is power of attorney for health care. That's what we call incapacity planning. That's another if. Some people get old, they get incapacitated, then they die. Well, you may or may not become incapacitated, but with dementia as rampant as it is, and, stroke as many strokes as we have a lot of incapacitation. So if something happens to you and you're still alive, but you can't make decisions, you need to have a trusted person in the wings ready to go to make these decisions for you.
Sure.
So, a part of estate planning is all those before death, during life decisions too. So, like I said, any good estate plan has that. If you have minor children, we do a guardianship nomination. That is a very underutilized or overlooked portion of estate planning, in my opinion. Because, taking the mindset that, well, if something happens to my wife and I, Aunt Gertrude will take care of the kids. Well, she may end up with the children, but that's not her legal authority to do so. That always results in a court order, guardianship. Mm-hmm. But there is a way, and this was not my topic, but as long as I brought it up, I might as well finish the thought.
You brought it up.
Yeah, I did. I opened what we call in court, I opened the door. So we, guardianship, there is a way to stack the deck very, very heavily in the favor of who we want that person to be.
Yes.
Okay, because we have guardianship always ends up in a court order, and the statute says if you nominate somebody during life to be a guardian for your children, the court has to give that great weight. And absent compelling reason why that shouldn't be that person.
Yes.
That's how, as far as I've been doing it, that's always been who it ends up being because of that. Because if you don't name anybody, here's what happens. And again, it's a good topic, but what happens is if you're a smart parent and you're in your younger years, now we're talking about people who have minor children, right? So you're in your 30s or 40s maybe.
Yes.
You have 2 or 3 kids, they're under 18. A smart parent will take out a pretty hefty term life insurance policy.
Yes.
Because you can get those pretty cheap, and you get them for hundreds of thousands of dollars, right?
Right.
And what you're doing when you do that is you're creating a situation, if something happens to me, I want something to stand in my shoes, at least financially, and take over for what I'm doing. I go to work every day, I make money, I take care of my family. So I want this $500,000 life insurance policy to stand in my financial shoes and take care of my family when I'm gone. And a lot of things we like to build into that is, okay, we got this house, it's got a mortgage, or in Tennessee it's called a deed of trust. But we want to have enough money in that life insurance policy to pay that off so they can live in a house unencumbered. You're in the real estate business, you know what I'm talking about.
I do.
And that's good planning that you do. Now, so we're talking about people at this age. Now, if you don't, here's the worrisome part. If something happens to you and you don't name guardians, it's up for grabs. Now, if something happens to you in your spouse, catastrophically. Sometimes the question, what will happen to my minor children if my wife and I don't come home from dinner tonight? You go out on date night, and it's like, what's going to happen to them if something happens?
It's not a pleasant thought, but
No,
it's something
not.
you should plan for.
But if you don't have any planning, if there's, when the police show up, two things are going to happen. The police are going to show up at the door. The babysitter's going to answer the door in response to either an accident, or the babysitter's going to call the police and say, listen, they were supposed to be home at midnight. It's 4 o'clock in the morning. I don't know what's going on. I'm scared. I don't know what's going on.
Right.
They're going to show up. And now, if there's nothing in place, it falls on them. And so what we want to avoid is, minor children going into the custody of strangers for even a minute, really, is what we want to avoid. Or the other thing is this, if you don't name who you want, you may have somebody in mind that, hey, Aunt Gertrude or my brother and his wife are the perfect people to raise the kids, because they have the same morals. I homeschooled. I know they homeschool, and
Right.
I want that to be done. We like to go to church. We're Christian, or oriented, or just the same morals and values. And
Right.
you may have a perfect person in mind, but if you don't memorialize it, it's up for grabs. And the thing that happens is, when it's up for grabs, people throw their hat in the ring because the court's going to decide. And the court doesn't know you. They don't know your values. They don't know your morals. You've not memorialized them.
Yes.
And so they're going to entertain, people throw their hat in the ring and say, I'll take care of the kids. And so there'll be a hearing as to why you're the best person. And for somebody else throws their hat in the ring, the court has to decide. So they're going to have to decide who it's going to be. And sometimes that's, the court looks at things like, their financial wherewithal, right? And the person you may pick, when my kids were minor, I wanted one of my sisters to do it. My poor sister, she struggled all her life. She always had a job, but it was a meager job. She was almost paycheck to paycheck. So she probably wouldn't look all that good on paper if the courts were looking at her. But she was the most wholesome person and the best person to raise my children if something happened to my wife and I, and that's who I wanted. But I don't know if she would have survived this process of the court deciding, because one of my other siblings that might have thrown her hat in the ring was a professional. He actually was a dentist, and his wherewithal was good. You want to question, can you afford to support these children? It was a slam dunk between the two, but that wasn't what I wanted, and it's my wishes that is what I want to be enforced. So
yes.
When why do people throw their hat in the ring? Well, sometimes if a big fat life insurance policy is coming with it, it gets people's attention. Okay, now I'm not, I don't want to talk about gloom and doom and the naysayer, but this is what we see happen. Okay, if a lot of money comes with raising these children through a life insurance policy, it attracts more interest. So the bottom line is, there is a way for you to pick the people you want in a successive order. There's also a way for you to exclude somebody you don't want. Every family's got it. It's like, okay, I want this person raising my kid, but I want to tell you what, I absolutely, positively do not want so-and-so raising my children, right? So there's a way to actually exclude a person discreetly. And the bottom line goal is, you want to get what you want, what your wishes are for your children. I get it. You and your, if it's just me, the other parent's going to be in custody. But if they're both gone, I get it. That's not the ideal situation, the parents being gone. Mm-hmm. So we're already dealing with the next best thing, right?
Yeah.
But that's what we're trying to solve, the next best thing. And you want it to be that way. And so the way to do it is just some sort of planning. Get this in the works so that when you're gone, your wishes are memorialized in an enforceable instrument.
Well, this is the great value in using someone like yourself to help you think through all the possibilities, all the issues, because for the layman like myself, you don't even know what questions to ask sometimes or what to think of. And you've had the experience, you've got the know-how and the law expertise to position your estate planning to help you accomplish all those goals.
Sure, and everybody has different family dynamics.
Yeah, absolutely. Absolutely.
All right, so I'm going to move into what we talked about last couple of weeks, and where this naturally progresses. And one thing I like to say on radio programs is, from time to time, you'll hear me get tongue-tied. You'll hear me struggle for a word, or I'm trying to make a concept, and I want to do this disclaimer. Okay, just kind of like the disclaimer.
There we go.
Here
We
on
need a
commercials.
disclaimer. Yes.
Disclaimer is, I'm not a professional radio announcer like yourself and the rest of the folks here at WDXE, and I get that. I mean, I do the best I can, and you will hear me get tongue-tied especially sometimes when I'm talking about a topic that I'm passionate about. I'll speed up. I'll be talking fast. Forgive that. I'm telling you right now, I apologize for that. I do the best I can. But I think the takeaway is I don't think that takes away from the information that's getting across, and that's
Sure.
and that's the
Not
bottom
at
line
all.
for this. So again, don't, if you think, well, you stutter a lot, well, I'm sorry. It's not that I'm nervous. Like I said, I just sometimes I think of stuff and it's like, I need to get that part out too.
Yeah, absolutely.
So we talked about last will and testament, how it goes through probate, and I talked about the probate process. It's pretty, it's a court proceeding governed by our probate code. It's riddled with time, with duties, obligations, and deadlines. And I remember I said there was 4 big disadvantages, and I'll go through them extremely quickly. The first one was it takes a long time. 12 to 16 months are the statistics I see in the state of Tennessee. And really, Tennessee is what I call a probate-friendly state compared to others. The other one is the cost. It can get pretty expensive. The third one was it's 100% public. And the fourth one, which I thought was the biggest disadvantage, was that when you get to the end, when you distribute property, it's an outright distribution. There's literally no terms or conditions you can put on it. Okay. Now, I'll revisit that in the future about what we call a testamentary trust, but I don't want to confuse it with that just now. So it's an outright distribution. So your kids get the money, they get the property. You can't really tell them what to do with it. They get it, ownership is complete, becomes theirs, right? So the only other possibility, and I said earlier in this show as well as earlier show, that there's only 3 possibilities: a will, no will, or a trust plan. Those are the will plan, trust plan, or nothing at all. And so that's what we're naturally progressing into, is a trust plan. And a trust plan, in my opinion, cures all the disadvantages of the will plan and the probate plan. So these are all choices. I guess doing nothing is a choice. I don't know that I know it's not the best choice, in my opinion, but I guess it's a choice to do nothing. So if you do nothing, you need to know what comes with that, and that's the probate process. If you do a will, you've done something in the will. You said where you want your stuff to go, but you're still going to go through probate. Now, anybody that's been involved in probate, and I'm not bashing the probate process. I mean, here's how it got to be so cumbersome. Wills have been around since the beginning of time.
Okay.
Or
Yes.
some instrument about leaving. I mean, like I say, it's talked about in Scripture. So leaving your assets to your heirs and children is not a new concept. I mean, it's if you research last will and testament long enough, you're going to get your feet wet crossing the Jordan River. Okay, so it goes back in history forever. So, but because of that, last wills and testament have really enjoyed a long history of abuse. And that is why they get to be, you heard me talk about them being formally executed and all the lengths we go through to make sure we have sound mind and disposing memory and witnessed and independent witnesses and witnesses that are in the sight and presence of each other and sight and presence of all the formal executions, all this to avoid the abuse and stuff. And that's just, probate process has gotten that way because of that. Because you can also imagine people have thought of anything and everything. If they don't like this will, they throw it away and they write another one, sign their dad's name to it, and say, okay, here's the new will, and it leaves everything to me.
Yes.
People are people, and that's all there is to it. So anyway, so it's this cumbersome process. Now, there is another way to distribute property after death, and it's the way to do other things during life and control how we distribute it after death. And that is called a trust-based plan. Now, there's a couple of different kinds of trust, but the one I'm going to talk about first is what we call the revocable living trust. You've heard the term. A lot of people say, well, why do you call it a revocable living trust? If you're going to make a trust, why would you want to revoke it? Which the reason it's called a living trust is because it goes into effect now during life. Remember I said the last will and testament, it has no legal significance whatsoever until the moment of death.
Yes.
Which is what testament means, at death. So, if you have a will, you can throw it away, you can tear it up. People say, can you do that to a legal document? During life, you can do whatever you want to it. You can throw it up, you can burn it, you can scribble on it, you can do anything you want. It doesn't have any significance until the moment of death. Now, a living trust goes into effect now. We draft it and put it together, and it goes into effect now. And they call it revocable because you can amend this trust at any given time. as long as you're alive to do it. You can't amend it after death.
Right.
But during life, if you're alive, you and your spouse are alive, or one of you is alive, there's a certain amount of adjusting, modifying, amending that you can do. And it gets its name revocable living trust because you can actually amend this thing all the way up to the point of like 100% amendment by revoking it.
Okay.
And undoing it. That's kind of how it gets its name, and a good way to think about it.
Sure.
I don't know hardly anybody that gets a revocable living trust and then revokes it. Now, we have done that if somebody has one that was poorly written and they're in another state and they move to Tennessee and they do one and they just want to ditch the old one because it wasn't one addressed to what they wanted. But you can do that. So if we have this concept of a revocable living trust, it is what we call a 100% probate avoidance technique. So if you have a trust and it's properly funded, you never go to probate. You never go to the courthouse. It solves all these problems, and I'm going to go through these problems. But the best way to do it is you put your property into a trust. Now, if you remember a while back, a couple of Fridays ago, I made the comment that there was a concept, I'd say, commit to memory. And the concept was anything you pass away with owned in your name, as you, the individual, must, by legal definition, go through probate. So if I pass away with my house and the acreage is on, it's titled to Stan Pierchoski, and I die with it titled that way, it's got to go through probate because we got to create this legal fiction of the estate of Stan Pierchoski and do what my will says to maintain the chain of title and stuff like that. So, and I even said, you might ask the question when I say that, well, gee, Stan, whose name would my stuff be in? Okay, It's all my stuff, and why wouldn't it be in my name? Well, now we're getting to that. And what we want to do is we want to put your property into a trust. And the way we do that is we retitle it to you, the trustee of the trust. Okay, and now it's not in your name; it's in your capacity as the trustee of this trust. So when we have a revocable living trust, if we put all our property into it, there's nothing to go through probate because when you pass away, let's say your house is in the trust. Your personal property, which is all your stuff, right? Your bank accounts, your investment accounts, your whatever, all these things are in your trust. Now, if you pass away and say, okay, what was titled in Stan's name as an individual? Well, there isn't anything. So if I have a will, it's all dressed up with no place to go. There's nothing for it to do. Okay, but now everything's titled in my name as the trustee of the trust, in my capacity as trustee, and not my capacity as an individual. Now that triggers our trust code for the descent and distribution of property. And now we go through how that gets distributed outside of probate and all that. So what does that look like? We call it funding the trust. Okay, let's put it this way. If you're in my office, and I know we're on radio, so let me try and describe this. If you're in my office, I have this big whiteboard on the wall, and I'll draw a box, and I'll say, okay, this is the Hood Living Trust. Okay?
Here we go.
I draw a box. When we draft this document, when you tell me the ideal end result and I figure out what it's supposed to do, we draft your trust. Someday we get together and sign it and do what's necessary to put that into effect. We have made your box.
Okay.
But the minute we make your box, it's empty. There's nothing in it. And it couldn't be because we just made it, right?
Right.
It doesn't exist until we create the plan.
Right.
Now we do funding the trust. It sounds like people say, well, that sounds like it's going to cost me money. Well, the term is not very descriptive, but what the funding is we move property that's not in the trust, it's in our individual name, into the trust.
We're going to fill the trust.
So you hear the term in the trust. My house is in the trust. Attorneys use the term. Everybody on the street vernacular says, yeah, I got my property in a trust. There really is no such thing as in the trust. The trust is a legal fiction. It can't own property. What we mean by in the trust is the property is vested with the trustee. So how does that look? I'm going to use a deed. You're in the real estate business. You can fact check me here. And
okay.
The reason I use a deed is because you have this document that you can look at and see exactly what happened.
Yes.
So when you're in the real estate business, people buy and sell stuff. We maintain this thing called the chain of title. This guy owned it. He sold it to this guy. This guy sold it to this guy. This guy sold it to this company. This guy gave it to his kid. This guy. And when you do a 30-year warranty deed title search, you follow this thing back. So I got a piece of property. I'll use you, Jeff. It's a piece of property, and the deed says Jeff Hood. It probably says you and your wife, but let's just keep it rather edux for now. We're going to make it just Jeff Hood.
Okay? I got it.
So we look at it at your deed right now. In the upper left-hand corner of the deed, we got these players. One's called the grantor, and that's going to be John Doe, the guy you bought it from. Okay, or if it was given to you by somebody, but nonetheless, that was the previous owner, and it goes to you. It's probably a warranty deed, and it goes to you. And now the new grantee is Jeff Hood, and if it's your wife, it's Jeff Hood et ux, which is Latin for and wife. So that's the new owner, but you own it in your individual capacity as Jeff and his wife, right?
Yes.
What's your wife's first name?
Teresa.
Teresa. So it's Jeff and Teresa. And so we have this trust, and we made the trust, and we want to put your house in the trust. So we want to maintain chain of title, so we draft the new deed. Now, the new deed, the grantor, I guess the person you can consider in the selling position if you're looking at sale, but this is not going to be a bargain for sale or exchange, but you have the grantor is going to be Jeff and Teresa Hood, the individuals, right? It's going to be a quick claim deed because it's not a bargain for sale or exchange. We're just reconveying ownership, okay? It's kind of a conveyance. It's a conveyance of property, but we're reassigning ownership. Now, the new the new grantees are going to be Jeff and Teresa Hood, trustees of the Hood Living Trust, okay? Now, that action puts your land and your deed into the box, in the trust. Because what have we done? If you pass away, hey, I don't own the house in my name. It's vested with me as the trustee. And now we have written in a trust where the property in the trust goes. So let's say it goes to my kids. Well, that property is going to your kids probate free because it's going to them under our trust code, which doesn't involve the probate process. Okay. So if you want to know what funding a trust looks like and how you put property into it, that's a good example because you can take your deed and you can look at it and see exactly what happened by this chain of title concept. Now, the other property doesn't have stuff like that, like your personal property, your stuff, your pots, your pans, your tables, your chairs. We do the same thing. We move that in, but we don't have title ownership to look at when that happens. But we can still assign all your personal property to the trust, and we do. Now, you go to the bank. It's the same thing with the bank. You go to the bank and say, hey, I've got a bank account here. It's titled to, myself, Jeff and Teresa Hood. It's a joint bank account. I did one of Mr. Stan's trusts, and we would like to change the ownership from us to us, the trustee. Now, the bank is going to know exactly what you're talking about. Banks are no strangers to trust law. Practically every bank I know has a trust department, so they know. But here's the way it's going to work. And they won't even ask all these questions, but they'll say, no problem, we know just what to do. But you need to prove to us there really is a trust, because banking law says we can't make an account in the name of a trust if one doesn't exist. That's considered a vehicle of abuse. So, when we do trust plans for people, we generate a thing called a certificate of trust, which is what the bank is looking for. As a matter of fact, they won't even go through all that. They'll just say, great, we'll do that. Do you have a certificate of trust? And yes. So you give it to them. But that's why they're asking for that. So when they get that, they're going to say, okay, so they don't even make it a new bank account. They're changing the ownership of the existing one. So, and that's great, because if you have a bank account, you got automatic deposits and automatic ACH withdrawals, and stuff like that. If you make a new bank account, it disturbs all those, right? Kind of like when you get the call and find out your credit card's been compromised and you have to get a new one. Yeah. Had any automatic things, sooner or later you're going to get an email that says, hey, well, you tried to run the card and it didn't work. Okay, here's the new card. So they just change the ownership of the bank account you have now. Right. They changed it from Jeff and Teresa, the trustees. Right. Now that whole bank account is in the trust. Now it doesn't matter what the balance is. It doesn't matter if it's $5 in there or $5 million. I mean, the vehicle is in there, okay? Right. So when you say, okay, the trust says, okay, my kids get an equal share of all the money we have in the bank. Well, that passes outside of probate, because it's in the trust. We do that with all our property. We do it with the deeds. We do it with bank accounts. We do it with investment accounts, like Edward Jones, Raymond James investment accounts. We do it with any other kind of property that you have. Now, if you have other property that's in the form of a beneficiary-driven thing, like life insurance or 401k retirement plans, those are all beneficiary instruments. We change the beneficiary to the trust, okay? Because we want it to go to the trust and let the trust control the distribution. And I'll explain that if I have time today. If not, we'll get it tomorrow. But if we do that with everything, funding the trust. And by the way, this is a pretty simple process. I get people that do it in a week, couple of weeks. If you don't, got to take a little bit of time here and there. It's a couple trips to go to the bank. Now I put everything in for you. If you do one of my trusts, I put everything into this trust for you that I can do for you. Sure. So I'll draft your deed. Let's say you only have the one deed. At the signing of the trust, I'll have the deed I just explained ready.
Right.
So after we make the trust, sometime after that, during that signing, we're going to sign the new deed. So that's in already. Okay.
Yeah.
And I'll do the assignment of personal property, which is all your stuff: pots, pans, tables, chairs, untitled property, including cars. We incorporate cars in personal property since we've incorporated the Uniform Trust Code. But so you don't have to change those titles. But now there's some things I can't put in for you, like this bank account. If I go to your bank and say, listen, I want to put Jeff and Teresa's bank account into this trust, I mean, they're going to probably show me the door because you have a contract with the bank, right?
Yes.
And I'm not on it.
Right.
So
right.
they're not, but basically what they'll say is, great, we'll be glad to do it, but they need to come in here
They need
and
to
do
do
it.
it.
Okay.
That's right.
So, there's some things I can't do for you, but I've got all the documentation that you need to do it. And I have a good working relationship with many, many, many banks for counties around. And they all, when you walk in there and you say, I did one of Mr. Stan's trust, they know exactly what's going on and
Sure.
what to do. So the idea is we put everything into it. And if we put everything into it, the goal now is when we pass away, nothing goes through probate. It all goes through this trust administration, which is a non-court intervention system, kind of non-adversarial in a way. I mean, people can challenge things, but it solves all these problems I talk about in probate. And I probably won't have time to go through them, but because some of them I like to spend a little time on how beneficial it is. But
Quick question.
Sure.
On the deed to a property, for instance, you've put it in the trust, or you funded it in the trust.
Correct.
You did that terminology. But let's say 2 years from now we want to sell that property.
Okay, good question. Now, if you want to sell it, now with a revocable living trust, you can do whatever you want with the property in it. You can put it in, you can take it out, you can sell it. You can, if it's your property, you can do anything you want. Now, but if you want to sell the property to John Doe Public, okay, a third party buyer.
Yeah.
Okay.
Yeah.
You want to, now the deed that makes the chain of title, the grantor is going to be Jeff and Teresa, trustees of the Hood Living Trust. Two, and it'll probably be a warranty deed because it's a third party. Two, the buyer, John Doe Public, and you can do that anytime. So and now some people say things like, okay, if I put the property into my trust like that, well, like we did. So
Yes.
let's back up before you just sold it. Okay, it's in the trust, right?
Yep.
They say, well, can I still sell it? What we just talked about. Can I? I'm limited in what I can do with it. Okay. Before you put it in, and it's titled to Jeff and Teresa, the individuals, you can sell it if you want to.
Yep.
Because you own it.
Right.
You can lease it out or rent it.
Right.
Because it's yours. You can grow corn on it if you want.
Right.
I mean, you can go torch it if you want. It belongs to you, right? You can do whatever you want.
Yeah.
Now, when you move it into a trust, the only person that can control the property in the trust is the trustee.
Okay.
Now, you can do it. Can you sell it? Yeah. You, the trustee, can sell it. Can you rent it and lease it out? Yeah. The trustee can do that. As a matter of fact, the trustee's the only one that can do it. And can you grow corn on it? Can you torch it? Can you do anything you want with it? The answer is it is absolutely seamless to you. The legal end of it is you are just simply acting in a different capacity. You're not an individual capacity. You're acting as trustee.
Yeah.
But it's from your day-to-day life, it's seamless. Same thing with your bank account.
I was going to say same thing with the bank account.
Well, people say, well, in the upper left-hand corner of my checks, it says Jeff and Teresa Hood. If I put my bank account in this trust, do I got to change that to say Jeff and Teresa Hood, trustees of the Jeff and Teresa Revocable Living Trust, dated June 13th, 2023, and any successors thereof?
Right.
Okay, the answer is no. I mean, if you did, it wouldn't be wrong, but I don't advise you do that. There's no need.
Yes.
When you change ownership, the bank knows who owns it.
Right.
And actually, if you put all that on your check, I think some places you take it might say, I don't know if I want this. I don't know this. I've never seen anything like this before. That's not necessary, and I don't advise it, because when you have a trust is viewed under law as an individual, not an entity. So you're not a business entity. You're not an LLC. You're not a corporation. You're not one of these partnerships. You're not a business entity. You are. The trust is viewed as an individual. So it's really very, very seamless to you when you put it in. And if you want to take it out, you're free to do that anytime you want. You put property in and out every day of the week or never at all. It's completely, and so the answer is that. And so I was saying now, when one of the problems we had with probate, when it comes time to distribute property, in probate, we said statistics, which are kind of all over the place, are about 12 to 16 months is what I see. 12 months because we said creditors' rights stay open for that long, right?
Now, I don't have an idea if this is a call for you or not. Do you want to try this call?
Sure. I mean, we're kind of down to 5 minutes.
We're down to 5 minutes. I really don't know. Whoops. Not there anyway, so they left.
But,
Okay, sorry.
Yeah, that brings up a good point. Sometimes the answers to questions will take a few minutes. So
Yes.
let's call earlier in the show than later because
I was gonna say.
the 9 o'clock ending is kind of what radio calls a hard break.
Yeah, we do have a hard break
You know,
at 9. We got about 5 minutes.
Sometimes when there's commercials, those are kind of a little softer, but at the end, it's got to come to an end. So, let's just talk about this one thing before we go. And one of the problems I said with probate was it can take a long time. Now, it's all over the board on what it can take, but for the most part, you got creditors' rights to stay open for 12 months. It's hard to close an estate. 12 months after death, anyway.
Yes.
It's hard to close an estate before then because they can always surface. And you don't want to have a creditor surface and reopen the estate. So sometimes the court won't even let us close it. But so it takes a while before people can get the money. And so you may have children that need it now rather than a year from now, right? So
Correct.
One of the problems is distribution of property with a trust and trust administration. The distribution happens rapidly. Mm-hmm. It can happen the day after death. I mean, there's going to be mourning. People are going to be, when mom and dad pass away, people are going to be,
of course.
grief and mourning. But as soon as you want to start dealing with this, you can do it. Now, let me give you an example, like that bank account.
Yes.
How does a bank account? So you say in your trust, my bank account gets divided among my children. How many children are we talking about?
3 in my case.
Okay, 3, and maybe one of them is going to be the oldest. So let's say you name as the oldest child the successor trustee, the one that takes over after death.
Yes.
Okay. Now that person's job is just to do one thing and one thing only: get control of all the property in the trust and distribute it to the way the trust says to get rid of it. Okay.
Yes.
And suppose it says any money in the bank, divide 3 ways. Okay.
Yeah.
So your oldest child is the successor trustee. You guys are gone, and walk into the bank and say, I want to take control of mom and dad's bank account. And the bank's going to say something like, okay, under what authority are you taking control of your parents' bank account? Mm-hmm. And here's the documentation where they name me successor trustee of their trust. And you the bank, that it's in the trust because it's titled to them as trustee.
Right.
And here's death certificates to show they're not here anymore.
Yeah.
The bank will recognize that authority immediately and say, okay, what do you want to do?
Right.
And say, okay, how much is in there? Well, exactly $150,000 to the penny. And say, okay, I want to write 3 checks. $50,000 to myself, $50,000 to my brother, and $50,000 to my sister, and I want to close the account.
Right.
I say, okay. And you walk out of the bank, and that asset has been distributed just like that.
Awesome.
And I mean, no probate. You don't have to say, hey, court, this is what I have in mind to do. Can I do that? Okay, well, let's put it out to any adverse party. Everybody has 30 days to object. It's just like that.
Right.
Deed the same way. There may be a little delay with the deed because you got to get somebody like me to write it. It may take a couple of days to draft a new deed, but the new deed's going to say from oldest child successor trustee to where you said to go.
Right.
And then you just go hand on the deed, distributed just like that.
Right.
It is just a well-oiled machine. So I hear the music. I know we're getting to the end. So listen, let me just remind everybody, next seminar, tomorrow, Saturday, June the 10th, at 10 o'clock in the morning, right here, WLX Country Cafe, the back of the building. You can't miss it. Go to the bottom of the big tower. It's like the end of the rainbow. And come on in. If you can RSVP, that's great. But if you just want to walk in, you're welcome to. So call my office if you want to sign up for, register for that. Or if you just want to talk to me about something, you can give my office a call at 931-363-7222. Or we have an easy to go to website. It's estateplanstan.com. Now that's ESTATE.
That's right.
Plans. So it's estateplanstan.com. Don't worry about trying to spell my last name. That hangs people up. I think it's easy to spell myself. But
there you go. It is. Absolutely.
But if you have trouble, estateplanstan.com. There you can see the calendar and see when the seminars are. You got my email and my phone number, so you can call me or email me and ask a question that way. So I appreciate it. I love doing the show. I hope we get people to call in because this show is for you. If you have questions, call in and ask. I'm more than happy to answer them. So,
Stan Pierchoski, everybody, and good to have you again this morning. We really appreciate you coming in on Fridays. Don't forget the seminar tomorrow, and Estate Plan Stan is the website. Stan Pierchoski. Okay, that phone number for your office, also 931-363-7222.
Always a pleasure, Jeff.
All right. God bless, buddy.
This is WDXE, W287AA, and W237FD Lawrenceburg. Broadcast services of Prospect Communications.
He claims they've indicted, again, an innocent man. I'm Dave Anthony, Fox News. Former President Trump's reaction to being charged with federal crimes related to his handling of classified documents. 2 months after an indictment in New York City for falsifying business records, which he also calls a hoax.
We can't let this continue to go on because it's ripping our country to shreds.
Fox's Nate Foy's in New Jersey.
Former President Trump has been huddling at his club in Bedminster with his top aides for the past few days in anticipation of this indictment. The indictment itself remains under seal, but sources tell Fox News that former President Trump is charged with 7 counts, and they include obstruction of justice and illegal retention of classified information in violation of the Espionage Act.
Democrats cheered the indictment in tweets. Congressman Jerry Connolly wrote, "No one is above the law." Another House Democrat, Greg Landsman, called Trump a danger and toxic, and Congressman Jamal Bowman posted, "We must ban Trump from running again." Republican Congresswoman Nancy Mace just told Fox,
"You know, you're watching the executive branch try to take out their political enemies because of the accusations against the Biden family."
Now, just yesterday, Mace reviewed an FBI document detailing a